Okay. Good morning, friends. So, tomorrow is the exam. Utilize the time properly. So, there are around 400 MCQs in which we are going to complete within 3 hours. So, first we'll start with the Contract Act. Acceptance must be అటు సౌండ్ వస్తుంది నాకు మళ్ళా. ఓకే, లిసన్ ఫ్రెండ్స్. acceptance to be valid must be absolute, both absolute and unqualified, both be absolute and unqualified, be conditional, which means acceptance must be absolute and unqualified. Absolute and unqualified means without any condition. Acceptance to be made without any condition. Why? Because conditional acceptance amounts to counter offer. Acceptance to be valid must be absolute and unqualified. Okay. A proposal can be accepted. Proposal is a offer. If it be a proposal can be accepted by notice of acceptance, by performance, by acceptance of consideration of reciprocal promise, the answer is all the above, which means proposal can be accepted in the following ways. Now, competency of contract. What is a competency? Capability, competency, ability to enter a contract. Who having a capacity? Major, sound mind, not disqualified by law. Here, age required, soundness required, both age and soundness. Intelligence, the best answer is both age and soundness. Keep in mind, while solving the MCQs, first read all the options, then write the answer. Why? Because yes, if two answers are correct, most perfect answer you need to write as a answer. If all answers are incorrect, lightly linked answer you need to write in the exam. Okay. If only a part of consideration or object is unlawful, if consideration is unlawful, automatically it is void. If the consent is caused by undue influence, what is undue influence? Dominating the will of one party by another party for obtaining unfair advantage. One party strong and another party weaker. Undue influence exercised by the stronger party on the weaker party. Undue influence automatically voidable. Yes. Who is competent to contract? You say major, sound mind, not disqualified by law. Minor, yes, not competent. Lunatic, not competent. Pardanashan women, who shall use parda to cover the face, who shall not make any contacts other than family members. Contract with Pardanash women also considered as undue influence. Okay, only sound mind. Out of the answer, sound mind is the perfect answer. Generally, who having a capacity to enter a contract? Major, sound mind, not disqualified by law. Next, what are the essentials of valid contract? Tell me the essentials of acceptance, capacity, consideration, free consent, legality, lawful formalities, certainty, yes, possibility of performance. Okay, here what are the essentials of valid contract? Offer, acceptance, lawful consideration, capacity of parties, all the above. Yes, when one person signifies to another his willingness to do, or yes, doing anything known as proposal. Sir, for proposal only a person will give the acceptance. Where there is no proposal, he cannot say yes or no. For the offer only a person is going to say yes or no. Next, What is the effect of wagering agreement? What is an wagering agreement? An agreement between two persons under which money or money's worth payable by one person to another person on happening, non-happening of uncertain event. What is the effect of wagering? Wagering agreement is void. No suit can be filed. Wagering is void but not illegal. All the above is the correct answer. But if you go by depth, wagering agreement is illegal in the state of Maharashtra and Gujarat. But in regarding to this, all the above is the correct answer. A contract. What is a contract? An agreement enforceable by law. Here, agreement plus legal obligation, which means enforceable by law. Which of the following results? Yes, in a offer. Declaration of intention, invitation to offer, offer made by joke is not an offer. Advertisement offering to anyone who found the lost dog of advertiser. Yes, it is a offer, and that too it is a general offer. That too it is a general offer. Special offer can be accepted by, sir, general offer can be accepted by any person who having a knowledge, but a special or specific offer can be accepted, yes, by the person to whom the offer is made. An acceptance is not according to the prescribed mode. We'll see. Sir, generally, acceptance to be made in a prescribed mode. Where acceptance not made in a prescribed mode, then offerer having two options. He can accept, he can reject. He can accept, he can reject. If accepted, no problem. If rejected, the matter to be communicated to the offeree. If not communicated, presumed it as acceptance, and there is always a contract. If acceptance not according to the mode prescribed, but offerer decides to keep quiet, there is a contract. If rejected, the matter to be communicated. The matter to be to whom? Offeree. Okay. There is a counter offer. Sir, counter offer means offer to a offer. What is a counter offer, sir? Offer to a offer is a counter offer. Rejection of original offer. Counter offer is not amounts to acceptance, which is another offer. Now, counter offer. Offer makes a fresh offer. Offer is some query. Offer. This is the answer. The offer gives conditions for acceptance and introduced a fresh term in the acceptance. Acceptance may be revoked before the letter of acceptance reaches to the offerer. Sir, an acceptance can be revoked before full acceptance is complete. Before what is complete, sir? Full acceptance through a speedier mode. Advertisement to sell a thing by auction is a invitation to offer. Auction sale is a invitation to offer. A makes an offer to B by 10th and reaches by 12th. An offer complete when it reaches to offer 12th. B posts the letter of acceptance on 14th when reached to A on 16th. Listen, sir, here there is a confusion. A given offer to B. A given offer 10th, it reached to B 12th. B given acceptance 14th, it reached to A 16th. Yes, sir. Now, when offer complete, when it reached to offeree. When acceptance complete, when it reached to offerer. But they asked against A means B. Against A means B. For B, what is there, sir? 14th. There are two parties, A, B. If it is not A, then automatically B. B 14th. An agreement made without consideration is void. Why, sir? No consideration, no contract. Next, A promises to subscribe for a charity. That promise is a void contract. Why? It will not create any legal relationships. Consideration in a contract may be past, present, future. But as per English law, past consideration has no validity. But for now, for us, a consideration may be past, present, future. Next, A promises to compensate wholly or in a part a person who already done something for the promiser is enforceable. Yes, promise to compensate, even no consideration, no contract. For example, I lost my purse, who brought to me and given the purse to me back. I said I will give a party next month first. Yes, it is valid. The topic is what? Promise to compensate. Where consent is caused by fraud or misrepresentation, the contract voidable adoption of aggrieved party. Aggrieved party means suffered party. Next, where both the parties to a agreement are under a mistake, which means mutual mistake and mistake of fact. Where both the parties under a mistake and a mistake of a fact. That is what mistake first? Bilateral mistake. Bilateral mistake is void. What are the requisites of fraud? Representation or assertion, it must be false. The representation or assertion must be fact made with the knowledge of falsity, which means I know that is false, but I said it as a true. I know it is not as true, but I said it as a fact. By knowingly I did like that, then it is a fraud. So what are the essentials of fraud usually? Fraud made by the party, false representation, representation of facts, suffered losses, actually deceived. Here these three matched or not, then any of the above. A valuable consideration in the eyes of law. Valuable consideration in the eyes of law may consist of right, interest, profit, benefit, forbearance, determinant, loss, responsibility by other person, both A or B. Forbearance, staying calm is also a consideration. An agreement with or by a minor. Agreement with a minor is void ab initio, but you need to give best possible answer out of the options. Yes, then what is there? Void is there, then void, correct. If void ab initio is there, then you need to go for void ab initio. On attaining the age, maturity. Yes, a minor's agreement cannot be ratified. Yes, ratification means further approval to previous activities. No ratification if a contract entered during the period of minority. To make the contract valid, both the parties must be the majors. Next, a minor enter into a contract for purchase of necessaries. Necessaries are food, clothing, shelter, education, medicine. A minors enter into a contract for purchase of certain necessaries. It is, in this case, is liable to return the money. So minor property liable, but minor not personally liable, and a minor not allowed for exchange of a labor. Contracts made before the war with alien enemy, which are against to public policy, suspended and revived after the war when, if it is beneficial, if it is against, stand dissolved. Contracts entered with alien enemy before the war. During the war it is suspended. After the war revived again if it is beneficial to public. If it is against, it is stand cancelled. Dissolved means what? Stand cancelled. When a person positively asserts that a fact is true when the information does not warrant it to be true, he believes that as true and it has said it as a true, then it is misrepresentation. Okay. A promise made without an intention of performing. I made a promise to one of my article student, if you work hard, I will double your salary. Yes, but my partner asked, are you going to double the salary? I said, I am going to remove him. After he worked hard for 2 months, which means I made a promise, but I have no intention to perform. That is a fraud. Any doubt, sir? So we covered the Contract Act. Now come to the Sale of Goods Act. Bailey. Okay. Sir, a bailee has particular lien over the goods bailed. Sir, in a bailment there are two parties, bailer, bailee. Person who gives the goods, bailer. Person who receives the goods, bailee. Liens are of two types, general lien, particular lien. Particular lien, labor and skill involved. For example, I given my car to a servicing center for car servicing. Yes, labor and skill involved or not? He did the servicing and asked 10,000 rupees. And asked 10,000 rupees. I said, yes, I will pay. You do the servicing. After service completed, I refuse to make a payment. What he is going to do? He will keep the car with him. He will keep the car with him. Particular lien. But only the car that I given, not my phone. If I given the car for servicing, for example, if I given phone for servicing, if phone done proper, I fails to pay the servicing money, is going to keep my ring or my phone? That's it. For the goods bailed. The position of finder of lost goods is of bailee. Finder of goods having same rights of bailee. In addition to that, the following are additional rights. Right to recover the reward, right to recover the expense, right of sale the goods. That is in addition to that. So finder of goods having same rights of bailee. Next. A bailee fails to return the goods according to the bailer's direction. A bailee fails to return the goods according to the bailer direction. He take reasonable care of goods, but yes, still the goods are lost. The loss fall on the bailee. Why? He fails to return the goods. A who purchases certain goods from B by a misrepresentation pledges with C. The pledge is valid. What is a pledge, sir? Delivery of goods by one person to another person for security purpose. Here, who purchases? A purchases certain goods from B by misrepresentation. A having a voidable option here, but A pledges the same with C. A pledges the same with C. He is asking not the misrepresentation. He is asking the pledge is what? A purchases from B. Misrepresentation. AB's contract is a misrepresentation, voidable. But A pledges the same with C. He is asking about the pledge. It is pledged by non-owners. Yes, it is valid. Contract of indemnity is a contingent contract. Why? Because I said, invest in the Wipro. If you suffer the loss, I will bear the loss. I will bear the loss. It is for beneficial purpose of public, and it may happen, may not happen. Yes, it is a contingent contract. The definition of contract of indemnity given in the Indian Contract Act includes, what is an indemnity? Where one party promises other party to save the loss that may suffer by the contract of promisor himself or any other party, which means there is an express promise also. Where there are co-sureties, a release by creditor, one of them, listen sir, A, B, C are the co-sureties for X to give a loan to P. Here, A, B, C are the co-sureties, X is the creditor, P is the principal debtor. Yes or no? Surety amount is 90 lakhs. 90 lakhs. Okay. Creditor always asking C. If C pays, C can recover from A and B. Yes or no? Then, if the creditor is not asking, means they are not liable? No. Yes, they are liable. Where there are co-sureties, a release by a creditor of one of them does not discharge the co-sureties. Next, a guarantee obtained by a creditor by keeping a silence of material circumstances. Yes, it is guarantee obtained by creditor by keeping silence. Yes, a guarantee given, it is valid. What is a guarantee? A promise made to discharge the liability of third party in case of default. Who got the guarantee? Creditor. But by making a silence, is not disclose all the facts. Yes, it is valid only. A quasi contract. Wait. What is a quasi contract? Generally, it is not a contract at all, but it is valid by court of law. Yes. A quasi contract is a quasi contract in an agreement. Generally, valid contract fulfill all the essentials. Quasi contract not fulfill all the essentials, provided it is valid. First, it is a agreement. When an agreement is discovered to be void, any person who received an advantage is bound to restore it. Okay, I sold a product to you. If that product is fake product, you make the contract void. I may pay your money back. You may restore the product back. A minor supplied necessaries on credit. Yes, supply of necessaries to minor valid. Minor not liable, minor's property liable. Which means minor's estate means a property only. The finder of lost goods having the same rights of bailey. Quantum merit as much as earned. I said I will take 4 classes. Yes, for each class 1000 rupees. After conducting 3 classes, due to my health issue, I stopped class. Students required to pay 4000 or 3000? 3000, as much as earned. A agrees to sell 100 shares to be at rupees 75 per share. Okay. Delivery to be given 1st March. B refused to accept delivery on 1st March and price go down to rupees 60 per share. Subsequently, yes, A sold the shares at rupees 92. Here, who agrees first? A agrees to sell the shares to B for rupees 75. 1st March. Here B refused to accept delivery. B refused. Now, the price has go down to 60. What breach it is? What breach it is? Anticipatory breach. Yes, they can recover the damages. Difference between market price and agreed price. It is like a attempted performance linked with anticipatory breach. Anticipatory breach taken place before the due date, before the performance is due. Specific performance may be ordered by the court when the damages are not a adequate remedy. For example, I said, I will give a gold pen to you. I am unable to sell. I am unable to sell. If court given gold pen equal money damage, if equal money damages, specific performance cannot be ordered. What is a specific performance? Directing through court of law to perform. If damages are adequate, specific performance cannot be directed. If it is not adequate, then only it can be directed. A undertakes to paint a picture of B. He dies before he paints the picture. The contract is discharged by death. Why? It is a personal nature. Personal nature contracts performed by person only. Okay, I made a promise to take your law classes. Yes, now I died. Can my car driver take the classes? No, it is a personal nature performed by person itself, promisor itself. A creditor agrees with the debtor and third party accept the a creditor agrees with the debtor and a third party to accept that third party as his debtor. Actually, it is perfect is novation. If not there, then a waiver. Intentional relinquishment of rights. As I already said that starting, if all answers are incorrect, lightly linked answer you need to write as an answer. If all answers are correct, best possible answer you need to write. Next, A lends rupees 500 to B. He later tells B, yes, that he need not repay the amount. The contract is discharged by waiver. A lends 500 to B. Yes, and A said, even you not pay the money, I won't ask. What the right that A have? He lost the right. Intentional relinquishment of rights. A lends to B and he later tells, A only tells, money need not required. What the right he have? He lost his right. Intentional relinquishment of rights. If a new contract is substituted in the place of existing contract, yes, it is a novation. Here answer wrong. Wrong answer. What is a novation? Substitution of new contract in the place of old or original contract. Answer wrong. Even in the CMA chapter book also. Yes, it is the novation. Which of the following are contingent contracts? Contract of insurance, contract of guarantee, wagering agreement, CRB. Contract of insurance, contract of guarantee, both A and B. D is the correct answer. An agreement to do impossible acts. An agreement to do impossible acts. Sir, here impossibilities are of two types. Initial impossibility, subsequent impossibility. Initial impossibility, both the parties know or don't know. Void, only one party know can claim the damages. Subsequent impossibility, void. So answer is incorrect. Void is the correct answer. A wagering agreement is, yes, generally wagering agreement is void, which means not permissible by law. Forbidden means prohibited by law. Change the answers also. The collateral transaction to a illegal. Yes, okay, I entered a contract to kill some person, but there is a proper checking. I asked a girl to bring the knife and supply the knife whenever I asked for. I entered a contract for 10 lakhs and I said to the girl, I will give Yes, 5,000. If you supply a knife, whenever I ask for the girl supplied a knife, I kill a person, and I killed a person. Yes, then police is going to arrest me or that girl, and both. Both. Collateral to illegal also. Illegal. A person enter into a agreement whereby he bound to do something which is against to the public or professional duty. A person enter into a contract whereby he is bound to do something which is against his public or professional duty. No, answer is A. This is also wrong answer. Void on the ground of public policy. This is the CMA chapter material questions. But anyway, there are some wrong answers you need to rectify. Okay, we completed contract act, sale of goods act. First we will see partnership, then we will see the last. Partnership act. Lastly, we will see Indian Regulatory Framework enact LLP Act. Why? Because mostly students not having clarity in regarding the topics will go somehow depth for a better explanation. Indian partnership. An act of firm. Yes, we'll see. Any partner or the agent which gives a right enforceable. An act by all the parties by omission of all the parties. In a partnership, mutual agency is there. A partner is a principal by himself and agent of other parties. Yes, for a single partner, firm is liable. Now what is the correct answer? All the above. Partnership is the relation between the parties. Partnership is the relation between the parties who agreed to share the profits of the business carried by all or any of them. Does it means losses are not shared? No, ma. Yes, here sharing of profits is only sharing of profits. Why? Because some partners are there. Yes, partners for profits only. Sharing of profits is a right. Sharing of loss is a duty. A person who share the profit does not imply he will share the losses also. Why? Because a type of partner is there. What types are? Partners for profits only. Any doubts? Okay. Now a minor may be admitted to the benefits only for profits. He cannot share losses. Yes, it also depends on the partnership agreement. Sharing of profits also include losses, negative. All the above is the correct answer. Mike, coming now. Okay. Who can inspect the registrar? Registrar means here ROF in a partnership. In a company, ROC. Who can inspect the registrar and file the documents at the office of registrar? Any person. Why? Because office of ROC for a companies act, office of ROF for a partnership act is a public office. Any person can go, any person can view. Next, what are the rights of partners after dissolution? If partnership is dissolved, they have a right to share the surplus profits. They have a power to wind up the business. They have a property. First, firm debts applied for firm debts. Firm property applied for firm debts. And if they have a right to take. Yes, all the above. Big questions. Where a member of a firm has died or otherwise ceased to be a partner and surviving partner continue the business and the died partner property there with the firm without any final settlement. Yes, of accounts as between them and the outgoing partner of his estate in the absence of contract to the contrary, the outgoing partner or his estate entitled at the option of himself or his representative to share the profits made since he ceased to be a partner may be attributable to the use of his share and property of the firm. Only one thing, sir. A member died, remaining partner continued. Accounts are not settled. Until his property is there, he can share the profits. If his money is there, he have a right to share the interest. If interest rate not mentioned, the interest is 6%. Dissolution of partnership means only change in the composition of partners. Dissolution of partnership is not a dissolution of firm. Dissolution of partnership means between all the partners of firm, no. It means change the relation of partners, reconstitution, none of the above. Best is the change in the, yes, relation, change in the composition of partners. Best possible answer. In what circumstances a partner may retire with a express agreement? Yes, I am a partner, I said, once I got a placement in NCLT, I will retire. I got a placement, automatically I retire. If it is partnership at will, by giving notice in writing to other partners, by take the consent of all the partners, all the boys, the correct answer. What would be the position when a minor elects not to be a partner? Sir, if a minor on attaining majority being a major, within 6 months from the date of attaining majority or date of obtaining the knowledge, have a right to choose to be a regular partner or to withdraw from partnership. If he is not to be a partner, which means he is not interested to be a partner, which means he wants to withdraw from the partnership. Entitled to sue the partners for share of profits. His rights and liabilities continues those of minor until the date of public notice. He is not liable after the date of public notice. What is the best answer? All the above. After the partner death, the business continued with old firm name. Whether the legal heirs of deceased partner liable for the acts of the firm. The continued use of name of deceased partner thereof shall not make legal representative liable. Sir, generally if a partner retired, until the date of public notice, even he retired, he is liable. But death or insolvent partner not required to give public notice. If a partner who died, he not required to give public notice. If he dies, from the date of the death, the assets of a death partner in the hands of legal heir is not liable. Okay. But even one thing is there in the succession. What's if father dies, son is liable to the father debts to the extent of assets inherited from the father. The partner in a firm may, by contract between the partners, restrict the implied authority, extend the implied authority. Yes, none of the above. Yes, subject to a contract. So, partnership formed through by a agreement. They can frame up their own agreement. They can restrict the implied authority. They can extend the implied authority. Restrictions on implied authority are of two types. Statute restrictions, restrictions by a mutual agreement. Yes, both A and B are correct. Whether a notice given to a partner who habitually acts in the business of the firm or any matter regarding to the affairs of the firm will be deemed as a notice. Sir, notice given to a active partner treated notice given to a firm. That notice given to a active partner and he is not a fraudulent person, that is regarding to the business. Then notice given to a single partner treated notice given to all partners. It operates notice the firm except if the partner is a fraudulent. So 3 conditions to fulfill. Single partner notice treated as a all partners notice, which means partnership notice. First, notice given to actual partner. which means a working partner he is, and he should not be a fraudulent person, and that is regarding to the business matters. What would be the position if minor elects to be a partner? What would be the position where a minor elects to be a partner? His share in the property and profits which shall be same. Yes, correct. His rights and liabilities continue up to the date when he is a partner. Yes, correct. He become personally liable to third party since he was admitted to the benefits. All the above is the correct answer. Next. Where a partner has been paid a premium for entering into the fixed term and the firm is dissolved before expiry of term otherwise than by a death, where the repayment of premium is permissible. Yes, the topic is premature winding up. Yes, yes. Let me explain with an example. ABC started a firm in the year 2020. Now they continued up to 2024. A person P wants to be a partner. Yes, they said we created a goodwill. We completed the business from 20 to 24. Yes, we will let you to be a partner. Then how much of premium that you are getting into the partnership business? He said, I will bring 10 lakhs. But while he is bringing 10 lakhs, he asked how long the business to be continued. 5 years. If they stopped for 3 years, he have a right to ask the premium for premature winding up. In which cases, sir, he is not entitled for repayment of premium if dissolution due to misconduct. Yes. If he is not entitled for repayment of premium if no provision contained in the written. Yes, correct. He shall be entitled to premium. Yes, and thereof regarding as to the terms upon which he become a partner and length of the time during he was a partner. Yes, all the above. Whether a partner after a dissolution of partnership firm carries the business in the erstwhile name of the firm. Erstwhile means past. Whether a partner after a dissolution of the partnership firm carries the business in the name of old firm name. Old firm name. Yes. He can use the business name of the dissolved firm name if he brought the goodwill of the firm. Yes. A old firm is there. We closed the old firm, but one of the partner wants to do the business with the old firm name. He can do, but he will purchase a goodwill of old firm. Why? Because goodwill is the property of the firm. He cannot use the business name of the dissolved firm. Yes, if you not purchase the goodwill. He can use the business name provided there was a contract. Yes, A and C is the correct answers. C is also correct. So more correct is A and C. The state government may appoint the registrar of the firms of the act. Every registrar, every government employee is deemed to be a public servant. Who said? Indian Penal Code. As already said, Indian Penal Code already altered. Bharatiya Nyaya Sanhita now. All government employees are public servants. Even I said in the inspector topic, every inspector is deemed to be a public servant under Indian Penal Code. Non-registration of firm cannot affect the right of partner to sue the dissolution. It's affected. Will not. Right to sing claim not exceeding 100 in value. Yes, sir. Most persons, they are confusing this topic. As I already said while a class discussion, generally the firm is non-registered. What are the effects? No right to file suit on other partners or partnership firm. No right to, yes, file suit on third parties. No right to claim set off in excess of 100 if unregistered. Okay, let me explain. Firm, receivables, firm, payables. Firm receivables are 75 lakhs. Now we'll see it is okay. Firm unregistered, firm registered. Here receivables is, in the both cases, receivables is 25 lakhs, payables is 75 lakhs. Payables is 75 lakhs. Now, if registered, what will happen? Payable is 75 lakhs, deduct the receivables, they required to pay only 50 lakhs. If unregistered, payable is 75 lakhs, consider receivable only 100 rupees. Why? Because no right to claim set off in excess of 100. Even unregistered, they can claim set off up to 100. If registered, they can claim receivables total claim as set off. If unregistered, they can claim set off only 100 rupees. Now, how a firm may be dissolved? Sir, yes, modes of dissolution. With the order of court, without the order of court. Yes, first, without the order of court, mutual agreement. Second, compulsory dissolution. Except one partner, all become died or insolvent or business become unlawful. Dissolution on happening of contingencies. Dissolution by notice. If it is partnership at will. Okay. Dissolution with the order of court. Insanity, permanent incapacity, misconduct, persistent breach of agreement, perpetual losses, transfer of interest, just and equitable grounds. Now we'll see the question. How a firm may be dissolved by the court order? Yes, dissolved on happening of contingencies in accordance with the contract. What it is? Mutual agreement, sir. And what is the correct answer? All the above. Now see, where a partner become unsound, the court may dissolve on a petition of any partner. Dissolution with the order of court. Insanity, permanent incapacity, misconduct. Unsound means insanity only, na. If a person insane partner is going to apply. If insane said he is an insane, he is not an insane, sir. Yes or no? As I said while the class is going, if a genius knows he is a genius, he is a fool. If a fool knows he is a fool, he is a genius. If a MITHUN, Raghav, Udbhav are the partners. If Udbhav become insane, who need to apply? Udbhav is not going to apply. MITHUN, Raghav will apply. Any partner. Any partner. More clarity means other partner. Other means other than insane partner. If the assets of the firm are sufficient to discharge the debts and liabilities, the partner shall bear the deficiency in the, yes, as I already said, settlement of losses. First to be paid out of profits. Though there is a deficiency, paid out of capital. Though there is a deficiency, then profit or loss sharing ratio. Yes or no? Then profit or loss sharing ratio. On attaining majority, a minor decide and give a public notice within the prescribed period whether he wants to continue as a partner in a firm or will quit. What is the prescribed period? If a minor becomes a major within 6 months from the date of majority or date of obtaining the knowledge, whichever is later. Within 6 months from the date of attaining majority or date of obtaining a knowledge that he is admitted to the benefits, whichever is later. Okay. In which conditions a person may be deemed as a partner by estoppel or holding out, where he by conduct represents himself to be a partner, when knowingly permits himself or represented to be a partner, whether he expressed by words spoken or written, let the other partners, all the above. Not a partner, but represented as a partner by words spoken, by the behavior, yes, by the activities, yes, partner by estoppel or holding out. Measures XYZ is a partnership firm and XYZ are the partners. During the course of business travel, partner X recovered a sum of rupees 15,000 in cash from a debtor of the firm and credited to the personal bank account. The act well amounts to, here 3 partners are there. A partner recovered 15,000 from a debtor, okay, yes, and he credited in his bank account, misappropriating the funds. Firm assets, firm property used for firm business, yes, he collected the money from the debtor and has been deposited in his personal account. It is a misappropriating of partnership funds. What is the liability of retiring partner after the date of retirement? He continues to be liable. If a partner retire, if the type of partner not mentioned is an active partner, yes or no? Yes or no? If active partner retiring, he required to give public notice. If he not given a public notice until the date of public notice, they are liable. LLP, NI, and last the topic, introduction of law, we'll see last, will take much time. Now come to the Factories Act. Age of adolescent. Employees are of 3 types. What are they? Adult, adolescent, child. Adult who completed 18, adolescent who completed 14, child under 14. Adolescent worker age is 14. Certificate of fitness given by certified surgeon, yes, stating that the physical condition of the young worker is perfect, that is valid of 12 months. Whitewash, color wash to carried at least once in 14 months. As I said, cleanliness topic. Every day, yes, you need to clean floor, yes, staircases, chairs, benches. Weekly once clean with a disinfect powder. Yes, 14 once whitewash, color wash. 5 years one, yes, doors, windows to be painted and repaired. Very dash more than employees to be employees. Provision of cool drinking water to be provided, hot weather, 250. Drinking water we covered. Drinking water 6 meters away from latrines, urinals, pitons, drainages, contaminations. Drinking water should be wholesome. Drinking water should keep 6 meters away. Where employees are more than 250, cool drinking water to be provided, hot weather. Yes, it is 250. Shelters with suitable restrooms are provided if more than dash workers are employed, 150. So 100, 250, 500 is not the correct answer. Yes, as I said, while you eating, what required? Drinking water, shelters, restrooms, lunch rooms. No female child. Concentrate, sir. No female 6 a.m. to 7 p.m. Female child they given. No female child shall be allowed to work in a factory except between 8 a.m. and 7 p.m. If female given, 6 a.m. to 7 p.m. Compensatory holidays, as I said. So what is a compensatory holidays? Yes, for example, this is the December month. December month you worked for 3 holidays. Then I need to compensate. They worked in the holidays. I need to give working days as a holidays in the December month or immediately next 2 months. Immediately next 2 months. Then what is the correct answer? 2 months. Which of the following amounts to a safety measure? First aid appliances, yes, it is a welfare. Ventilation, artificial humidification, it is a health. This is health. This is welfare. Fencing, as I said, factories, yes, are to be fenced. Why? Because some buffalo, sheep, or any strangers, yes, can enter, can have an access, leads to an issues. Fencing is what measure, sir? Safety measure. Identify from the following what is the powers of inspectors. You say, and as I said, enter an establishment at all reasonable time, require an employer to furnish necessary information, make copies, make extracts, inquire from others, such other powers prescribed. Okay, if you, yes, slap a person in the class, a person filed a complaint in the police station, police officer will come to the class or not? Come to the institute. While come to the institute, they will ask the in charge what happened. Now, yes, they will take the CCTV footages and attendance extracts. They will inquire from others. At last, they will arrest you and put in the prison and give a favorable treatment matched for you. So, all the above is the correct answer. Weekly holiday, wrong answer, sir. First day of the week. Sir, weekdays are Sunday, Monday, Tuesday, Wednesday, Thursday, Friday, Saturday. What is the holiday, sir? First day, that is Sunday. Answer wrong. They given wrong. Okay. Which do not amounts to retirement. Which do not amount to retirement. Okay. Generally, retrenchment, resignation, dismissal, superannuation, not amounts to retirement. Resignation. What is superannuation, sir? Where the last day of service known to the employee. According to section 67 of Factories Act 1948, a child who completed, he shall required to or allowed to work in a factory. Child means 14th year. Okay. Factories Act provides dash to be, chapter 5 of Factories Act provide dash to be taken factory for workmen employed. Yes, for health, safety, welfare measures. Factories Act workmen employed. Workmen means employee. Directly we can link it with welfare. All are correct. C, D, both are correct, but best possible is D. Now payment of gratuity act. Okay, gratuity payable to employee. Sir, gratuity payable at the last day of service. An employee who completed, yes, 5 years of service. Employee who completed 5 years of continuous service eligible for gratuity. Gratuity paid at what day of service? Last day of service. Either death, retirement, termination, superannuation. All the above. Gratuity payable to employee shall not exceed. This is 20 lakhs. Say, question mistake, sir. Maximum gratuity shall not exceed 20 lakhs. Question mistake. For 1 year, 15 days salary for every complete year of service. The formula also there, 15 by 26 into average last drawn salary into number of years of service. Okay. An employee who display the abstract of Gratuity Act rules and regulations. As I said, there is a topic in the Gratuity Act display. What to display it? Abstract of Gratuity Act rules and regulations and the name of the officer to take care of gratuity. Here abstract and name of the officer to take care of gratuity. One in English, one in vernacular language. Yes, form U only. If sufficient cause shown to the appropriate government for condemn the delay in filing the appeal. Yes, again is the order of controlling authority. 60 days. Appropriate government condemn the delay. Nominations. Sir, nomination means what? Appointment of a nominee. Sir, who shall be a nominee? Family member. No family. Any person. Yes, who is eligible to appoint a nominee? Employee who completed 1 year of service. Which one of the following included in the definition of wage? Wage as per the gratuity act, basic pay plus DA. Now what is included? DA. If an employee intends to close the business, sir, change of location or nature of business within 30 days of change, inform to the controlling authority. Closure of business, notice given to controlling authority 60 days before intended closure. Nomination should be filed in always duplicate. Which will not amounts to service of notice under the rule? Here, courier. Sir, you only said it is under Companies Act, sir. Companies Act service of notice, registered post, speed post, courier, leaving at register office, any electronic mode. This is what act, sir? Gratuity. Gratuity, courier is not allowed. If there is a dispute as to amount of gratuity payable to the employee, the employer shall deposit the gratuity with the controlling authority. Yes. Controlling authority is the authority appointed by appropriate government to take care of gratuity. A right of receiving gratuity by the employee is a statutory right, which means it is given by the act. Statutory right is a right which is given by what? Act. Gratuity shall be payable to employee on the termination of his employment after he rendered not less than 5 years of continuous service. Who is eligible for gratuity? Employee who completed 5 years of continuous service. 5 years is not essential in the case of death or disablement. Gratuity paid at last day of service. So, who completed 5 years of continuous service. Gratuity payable to employee after he rendered service not less than 5 years in case of death or who is eligible for gratuity? Employee who completed 5 years of service. 5 years is not essential in the case of death or in case of yes, death case. Why? The purpose of gratuity act to avoid jumping from one organization to another organization. In case of death or permanent incapacity, even 5 years not eligible, 5 years not completed, is eligible to claim the gratuity. Transfer, daughter's marriage, re-employment, resignation is the best possible answer. If he died or permanent incapacity, he may resign. But out of all are incorrect, this one is lightly linked. So gratuity to be paid to the employee who completed 5 years of continuous service. 5 years is not essential in the case of death or disablement. Now, Employee Provident Fund Act and Miscellaneous Provisions Act. Which one of the following will not include the definition basic wages? Very important. There I said, in a basic wages definition, all emoluments which are earned by the employee while on duty, leave, holiday with wages excludes dearness allowance, house rent allowance, yes, overtime allowance, cash value of food concessions, bonus, commission, any similar allowance. For more clarity, employer contribution of PF is 10% for General. For big organizations, 12. Yes, 10% of basic pay plus DA plus retaining allowance. Yes, basic pay, 10% of basic pay plus DA plus retaining allowance, if any, I said. If it is included, what is the requirement to say plus? That is the requirement. I said the definition. Basic wages definition in the PF Act. Mostly all are feeling that, yes, the answer is incorrect. Yes, it is correct only. Basic pay, all emoluments which are earned by the employee while on duty, leave, holiday with wages in accordance with terms of contract of employment, exclude cash value of food concessions, dearness allowance, house rent allowance, yes, overtime allowance, bonus, commission, any similar allowance, any presents made by employee. Yes, all the boys the correct answer. Contribution of employer to insurance fund, deposit linked insurance fund. In what act it is? Provident Fund Act and Miscellaneous Provisions Act. There are three schemes. Provident Fund Scheme, Pension Scheme, Deposit Linked Insurance Scheme. Deposit Linked Insurance Scheme, employer 1% of total emoluments. Sir, many persons are in a doubt, sir. Even some books specifies PF 10, 12, both is there, sir. 10 for small organizations, 12 for big organizations. 10 for small organizations, yes, 12 for big organizations. Yes, contribution of 10% to PF is applicable. In our material, we clearly states 10, 12, both is there. Yes or no? Yes, 10, employees less than 20 years, sickness, jute company, none of the above is the correct answer. In our Shikara material, we clearly mentioned it. But ICA material given only 10. Some other author material they given 12. Both are incorrect. Both to be given a clarity. Minimum administrative charge payable by employer to the fund is, yes, it is 500. Maximum penalty recoverable from the employer who makes the default in the payment of contribution. Penalty then not stated, none of the above. Employee pension scheme provides superannuation pension, orphanage pension, both A and B. Yeah, A and B. Contribution to employees pension fund by employer 8.33. As I said, if PF it is 12, then 8.33 they used to give for pension, 3.67 they used to give for PF. The following cannot be nominated for the purpose of EPF Act. Wife nominated, father-in-law nominated, unmarried daughter nominated, sons of deceased sons. Sons of, if son died, grandson cannot be nominated if he attains majority. If he attains, yeah. While filing an appeal to appellate tribunal, how much money to be deposited? 75% of amount demanded to be deposited. It can be waived or reduced by the appellate tribunal on satisfying valid reasons. Why, sir? The deposit money to avoid the fake cases. If you won the case, that money to be refunded. The contribution shall be paid within dash days, 15 days from the end of this month. Withdrawal from provident fund shall not be allowed. So first, withdrawal allowed for dwelling houses, which means residential house, marriage of children, repayment of loans in special cases, withdrawal 1 year because repayment. Yes, here advance is different, withdrawal is different. Yes, purchase of dwelling houses. Wait. No, answer incorrect, ma. C is the correct answer. C is the correct answer. B is the correct answer. Withdrawal permissible for purchase of residential house, residential flat, land, plot for construction of residential house, repayment of loan in special cases, marriages for him, post matriculation education of children. Marriage of children not allowed. This is the correct answer. Answer is incorrect here. Sir, withdrawal possible. First see the act theory, then you can understand. Withdrawal permissible for what cases? First, purchase of residential dwelling, residential house, residential flat or plot for construction of a house, and education, marriage of himself, post matriculation education of children, repayment of loan in special cases. Withdrawal 1 year before retirement not required to be repaid. The answer is marriages of children is not allowed. Marriage of himself allowed. Marriage of children not allowed. Marriage of education allowed. That too post matriculation education. Answer is B. C is not the right answer. Some answers are incorrect. I taken directly from your chapter CMA booklet release. Mostly they will ask from that only. ESI. An appeal shall lie to the High Court from the order of ESI within 60 days. A member of ESI corporation fails to attend 3 consecutive meetings. Consecutive means continuous meeting. In an ESI corporation, there are 3 levels. ESI corporation, standing committee, medical benefit council. Yes, combined topics. If they continuously fails to attend 3 meetings, their name to be removed. It can be restored if valid cause shown. 3 consecutive meetings. ESI funds consist of contributions of employer and employee, grant from government, public donations. All the above is the correct answer. The corporation may be established. The corporation may, with the approval of establish and maintain a state hospital dispensaries. Yes, state government. State government, yes, also there. Which among the following will not be considered as employee? Very, very important. As I said, employee definition includes Supreme Court cases, casual workers, canteen workers, part-time employees, employees working outside the organizations, outside the premises, but partners are not considered as employees. Which of the following is not a principal employer? Occupier is a principal employer, owner is a principal employer, legal representative of owner if deceased. Legal representative of contractor never be a principal employer. Seasonal factory is one engaged for a period not exceeding 7 months. Which of the following will not be included in the definition of wage? Traveling allowance. As I said once, the difference between traveling allowance and traveling concession. What is the traveling allowance? They will give a fixed sum of money. They will ask the employees to come to the organization in the mode of the transport that they want. Traveling concession. The employer is arranging a transportation. Yes, out of the money what they are incurring, they are charging some money from the employee. Traveling allowance not included in the wages. ESI corporation is a body corporate. Yes. As per the ESI Act, a member of corporation, standing committee, medical benefit council may resign the office by giving notice in writing given to ESI member. Answer incorrect. Central government is the correct answer. Listen, listen. Oi, central government is the correct answer. Wait. When it is approved, if central government approved, notice they given only to chairman only, correct. Under ESI Act, the term of office of members of medical benefit council, wrong answer again. 4 years. Standing committee 2 years, medical benefit council 4 years. Why they given these type of answers? Who is a insurable employee under ESI Act? Insurable workmen, mines, railways, insurable any member of Army, Navy, Air Force, all are covered under ESI Act. All employees in a factories or establishment in the Act applies. Family does not include independent married sister. Correct. Now, code of wages. Code is a collection of laws. Minimum rate of wages are fixed in accordance with hourly, daily, monthly, all the above. Section 20 deals with eligibility of bonus. Every inspector shall deem to be a public servant under Indian Penal Code. Section 21. Section 56 talks about composition of offences. Section 55 of Code of Wages talks about no. Wrong answer. This one is the wrong answer. Wait. Section 55. Offences by companies. This is the answer. A is the right answer. It's the wrong answer. A is the right answer. Okay. Take a break for 10 minutes. We already covered industrial laws, commercial laws by leaving Contract Act, so by leaving Enact, LLP Act, Indian Regulatory Framework. After the break, we will cover the topics Companies Act and ethics. Okay. Take a break for 10 minutes. I will come by 11:05 sharply. చూడు వ్యూవర్స్ 250 అని ఉన్నారు ఇప్పుడు రన్నింగ్ కదా రన్నింగ్ 3 నా 2-3 నెంబర్ చూసి వెళ్ళిపోయాడు ఇప్పుడు చూస్తున్నది 3 లైవ్లో ఉన్నది 3 నా వ్యూస్ అంటే చెప్పాం కదా ఆల్రెడీ ఓకే we'll start the Companies Act. Which of the following is not correct in regarding to the share certificate? Company secretary shall issue the share certificate is incorrect. Why? Company will issue the share certificate. The share certificate in record the resolution, share certificate distinguish to distinctive number. The shares may be in a dematerialized form. So this is the incorrect issue. Incorrect is the correct one. Then if a company does not have a common seal, the share certificate signed by 2 directors or a director plus company secretary if company secretary appointed, either A or B. A or B is the correct answer. In case of unlisted company, duplicate share certificate shall be issued within 3 months. Listed company 45 days. Listed 45. The bonus shares may be issued out of, what is the source of bonus shares? Free reserves, security premium, capital redemption reserve, all under the parcel of reserves and surplus. Yes, all the above is the answer or any of the above. For the purpose of security premium can be utilized for what? Issuing fully paid bonus shares. Yes, for providing premium for redemption of redeemable preference shares. Yes, writing of balance of preliminary expenses. Writing of commission paid discount allowed for issuing shares and debentures to public. Buyback of shares. Now see, writing preliminary expenses, bonus shares, issue of bonus shares. Yes, any of the above. Quorum. Minimum number of persons required to transact business in a meeting is called a quorum. Private company to public company, shareholders up to, yes, shareholders up to, yes, no, 1,000 5 members. 1,000 to 5,000 15 members. Yes, more than 5,000 30 members personally present. Here more than 5,000 and it is a public company. An instrument of the proxy shall be deposited with the registrar of fees 48 hours before the meeting. Proxy, if any person who is unable to attend a meeting, he can send some other person in his place a proxy form to be deposited 48 hours before the meeting. In case of e-voting, a notice shall be sent an attachment in a PDF form. Adjourned meeting, the company not given notice. Okay, sir, notice 21 days before the meeting. If no quorum, meeting shall be adjourned next week, same time, same place. Yes, sir, for adjourned meeting, notice 3 days is enough. Which one of the following is correct? The articles of company shall provide appointment of chairman in a meeting. Yes, it is correct. The members personally present at the meeting elect one of them. Yes. Managing director is the chairman of meeting. No. And company meeting, chairman meeting. Company meeting, yes, company chairman, meeting chairman is different. What I said, articles provide a manner for appointment of chairman. If articles is silent, out of the members present, one elected as a chairman. Managing director is not a chairman, it is incorrect. Which of the following is the method of voting? Voting by show of hands, voting through electronic means, voting by poll, all the above. Voting are of four types. Voting by show of hands, voting by poll, postal ballot, electronic means. Oh, all the above is the type of voting. A poll demanded on the question shall be taken within 48 hours. Immediately also there for demand of election of chairman and for adjournment of meeting immediately. For other cases 48 hours. Which One cannot be transacted through a postal ballot. Appointment of auditor. Yes. Assent or dissent after dash days in a postal ballot. 30 days. Assent, dissent received after dash days in a postal ballot from the date of notice shall be treated as if no reply has been received from a member. 30 days. If an inspection is refused or if any copy required to be furnished within the specified time, the company liable to pay penalty 25,000. Minimum directors of private company 2, public company 3, maximum 15. What is the paid up share capital for appointment of women director? In ICA material they are not given, but they are asking. Paid up capital 100 crores, turnover of 300 crores. Out of the board of directors, one shall be women. Yes, in case of old companies, needs to be appointed within 6 months. Paid up capital. This is not there in the syllabus, but they are asking. What is the paid up share capital for appointment of women director? That is fixed by general meeting. The tenure of director appointed by small shareholders. It is not there in the ICS syllabus, but there are small shareholder means shareholder capital less than 20,000. Small shareholders. Yes, director time period is 3 years. How much, sir? 3 years. No independent director shall hold office more than 3 consecutive terms. This is the old taken questions. These are not there in the present chapter book. Where a public company required to appoint a independent director. Public company turnover 100 crores or more, share capital 10 crores or more, outstanding borrowings 50 crores or more, all the above. Which one of the following is not a criteria for appointment of independent director? He shall not be a promoter. He shall relate to the promoter, not a criteria. Yeah, this is the correct answer. A director elected by small shareholders upon a notice not less than 1,000 or 1/10 of such shareholders, whichever is lower. Independent, small, not there in the books, at least even a chapter material. At every AGM, not less than 2/3 of directors shall rotate, 1/3 of directors shall vacate. Minimum age 21 years for appointment of managing director. Which one of the following is correct in regarding to the share certificate? A company shall issue a share certificate. Not correct. Company secretary will not issue. Company will issue. The one-person company gives independent entrepreneurs all the benefits of company. Under section 2, subsection 51 of Companies Act 2013, who is not defined as a part of key major person? Independent director. So key major person means, as I said, CEO, CFO, CS, managing director, whole-time director, yes, one level below director. One level below. These are the key managerial persons. Independent director not be defined as a part of key major person. Where inspection is refused or if a copy not furnished within the specified time, company pay a penalty 25,000. Which one of the following is not a criteria for appointment of independent? Again they given. Means a company which is a company in which that other company has significant influence, associate company, 20% of share capital. Annual return of one-person company in the absence of company secretary shall be signed by director. Common annual return signed by director plus a company secretary. Where no company secretary in practice. For one-person company, company secretary. No company secretary, director. Startup company may issue sweat equity shares not exceed 50% of paid up capital for 5 years. Where auditor is dissatisfied with the information provided and find he cannot express the proper opinion, disclaimer of opinion. As I said, audit opinions are of 4 types: unqualified, qualified, disclaimer, adverse. Unqualified, clean report without any mistakes. Qualified, except that mistake, rest of all perfect. Disclaimer, unable to express the opinion. Adverse, wrong. Books of accounts are not proper. Every listed company shall establish a visual mechanism to report to directors and employees. No prospectus shall be invalid if it is issued more than 90 days. No prospectus shall be valid. Sir, requirement of prospectus. Prospectus must be dated. Every prospectus must be dated. If not, date of publication is the date of prospectus. Prospectus filed with ROC for registration. Within 90 days from the registration, it is to be issued. If not, it is invalid. Private placement. Once should not exceed 50. In an year should not exceed 200. 1 year. Once 50. In an year should not exceed 200. Quorum of public company more than 5,030 members. For selecting the name of company, application shall be made in INC 1, Incorporation 1. Where the equity shares of the company are listed in the recognized stock exchanges, the issue of such shares shall be approved by shareholders voting through electronic means. Unlisted company, duplicate share certificate. Unlisted. Earlier we seen listed or unlisted. Check once. They given one wrong answer, one right answer. Yeah, here also the same. Unlisted 3 months. Listed 45 days. They taken from earlier exam questions and they're directly printing. So the provision of Rule 20 regarding voting by electronic means shall apply. Applicable to muttatis, muttandis means alike. Hereby muttatis, muttandis same with alterations as required. Meaning of muttatis, muttandis. Okay. Revise the IDT as per the manner I said. Sir, what about muttatis, muttandis of IDT? Small alterations if required you can apply. The registration of charge not done in 30 days. The registrar may allow registration within 120 days. As I said, charge before cutoff date 2nd November 2018. Yes, after 2nd November, first within 30 days. Extra 30 days with a normal fees. Again 30 days with a additional fees. Again 60 days with a ad valorem fees. Total it is 120 days. Annual return of one person company signed by director. Yes, managing director, age 21 years. A company cannot remove a director appointed by tribunal. In case of private company, mention the number of members personally present to form a quorum. Private company, two members. Which of the following is not a medium of sending a notices? You say service of documents section 20. Registered post, speed post, courier, leaving at register office, any electronic mode. Through public advertisement not allowed. This is the correct answer. Not a valid medium. If any default is made in filing refund of money, the company and every officer who is in default shall liable to pay a penalty 1 lakh. Annual return signed by one person company, company secretary, no company secretary, director. Many times they asked. If there is a misstatement in prospectus, it would attract the liability of issuer, not the printer or publisher. Issuer means company. Who will issue the prospectus? Company. In case of misstatement in the prospectus, who is liable? Company liable. Every company limited by shares shall keep and maintain the register of members in MGT 1. As I said, yes, members register MGT 1, debenture other security register MGT 2, foreign register MGT 3, annual return MGT 7. Which one cannot be transacted through a postal ballot election of director? The appointment of independent director shall approved by general meeting. Sweat equity shares lock-in period. Sweat equity shares are the equity shares issued by company to employees or directors for providing know-how, making available rights in the nature of intellectual property rights, value additions if any. Lock-in period 3 years to create a belief that they are also owners. They should hold a minimum of 3 years. Which of the following is not a category of company? Inactive company, dormant company. Dormant company. Assistant company is not there as of now. Associate company is there. Assistant company is not there. Section 92 of Companies Act 2013 requires a company to prepare and file annual return MGT 7. The instrument of proxy shall be deposited registered within 48 hours. Wrong answer. 48 hours. Which one of the following is not correct? The articles of company shall provide appointment of chairman. Okay. Managing director is not a chairman. It's already covered, sir. Chairman articles provide for appointment of chairman. If articles is silent, out of the members, one person elected as chairman. If a company does not have a common seal, the share certificate signed by 2 directors and a company secretary. E-voting PDF file. Director elected by small shareholders. 1/10 of small shareholders or at least 1,000 members, whichever is lower. It's an old material question. Which of the following is suggesting that one person should not occupy the role of chairman, chief executive director of public listed company? Cadbury committee report. Board of directors of a listed company, yes, audit committee. What I said, sir? Audit committee should consist of minimum 3 directors. Out of that, independent director shall be the majority. Maximum limit of bonus 20%. This is the bonus act now. Why they here? Ethics. The relation between law and ethics is not simple. It is complex stuff thing. Yes, if law not followed, it is punishable. If ethics not followed, no punishment. It is complex to define the difference between law and ethics. Many laws are representative to the ethics. Okay. Now, in the metro or buses, lady seats, only ladies allowed to sit. Yes or no, sir? There is no gents seat separate. Only ladies are compulsory reserved seats. Yes or no? Why? Indian tradition to respect the ladies. So many laws are representative to the ethics of time. Law gives us certain right because all humans are born equal. Sir, even may height difference, all are equal only, sir. The role of accounting is management accounting, problem solving, scorekeeping, attention directing. Problem solving, they will evaluate the alternatives how to solve a problem. Ethics are set of moral principles that guide a person's behavior. The following are the disadvantages of business ethics. If they are thinking about ethics, yes, they cannot achieve their goal. All good persons, they are thinking about the public, they will difficult to achieve their goal if they are set a high level of profits. Almost every company now has a business ethics program because of technology, digital communication have made easier to identify, publicize not moral duties, ethical missteps. Yes. Why? Because in some companies, yes, they used to bring some motivational speakers to talk about the ethics, or some persons who are giving pravachanas. Tell me a person who name pravachanas. Many persons are there. Yes, a proper foundation of ethics requires standard of life, good things, standard of value to which goals and actions compare to. Which one of the following is not a attribute to a emotional intelligence? You say emotional intelligence, 4 attributes are self-management, self-awareness, social awareness, relationship management. Corporate management is not a attribute. Holders of public office must act and take decisions impartially, fairly, on merit, using the best evidence without discrimination or bias. The principle of public life is known as objectivity. 7 principles of public life: selflessness, integrity, objectivity, accountability, openness, honesty, leadership. Without discrimination showing is a objectivity. Selfless means, yes, they should think less about them, they should think more about the public interest. 7 principles of public life are selflessness. Moral management requires ethical leadership. Meta-ethics deals with moral judgment. I said, yes, whatever happens, if there is a fight between male and female, faculty or public used to support female only. Business ethics also called as a corporate ethics in the form of applied ethics. Business ethics are needed to create faith about quality, quantity, price of the products. The customers have more trust and faith in the businessmen who follow ethical rules. They feel such business person would not cheat them. Which one of the following improve customer confidence? If I go to a shop, I will purchase Mysore sandal. Why? It is a Mysore dynasty, Vadiyar group. Yes, they are doing perfectly. If you purchase any Tata water, are you going to feel the bad? No. Why? Tata group never, yes, release waste quality products. We have faith on Tata by seeing Ratan Tata in our generation, in old generation J.R.D. Tata, which is a more great person than Ratan Tata. Holders of public office should not place themselves under any financial other obligations that may influence integrity, which means they should not be influenced by others. There are many types of ethical conflicts in the workplace. Which one of the following is said to be a unethical behavior? Encouraging communication, economic cycles, employees awareness. Not why, sir, unethical behavior? Sir, some sensitive information carried by the organization should not be leaked to employees. The study of ethics can be divided into 4 operational areas. Old one. Now it is 3 only. Meta-ethics, normative ethics, applied ethics. Some other earlier is there, descriptive ethics also. Now applied ethics. Generally for us 3, but earlier books 4. Meta-ethics, normative ethics, applied ethics, descriptive ethics. Descriptive means words explaining ethics. When a professional promotes the position or opinion to such extent that some objectivity may be compromised, it is advocacy threats, which means, yes, to an advocate we will leak all the information. He is not allowed to disclose. The crucial step of understanding business ethics is establishing code of ethics. Crucial, not a crucial step. Learning to recognize ethical issues. You should think in the issue way, not in your own way. Which of the following reason is applicable for Unethical business practices, workplace surveillance, profit, success, administrative corruption is the unethical business practice. Why? Because if high level authority did a fraud, it will act as an encouragement for low level employees also to follow. Now, business ethics is based on well accepted moral and social values. Out of 7 principles of public life, objectivity means take a decision based on a merit without showing discrimination. Who is responsible for ethical behavior? Lecturers to some extent, psychiatrists, parties, community. Based on the society only, mindset will be changed. So, come to the first chapter. Introduction of law and legal system. Right to property is a constitutional right. Constitution given a right. Constitution of India described, as I said, it is a collection of the states, union of the states. Constitution is the law of land applicable only to India. What is the chief source of legal authority in India? People, Constitution of India, Parliament, President of India is the supreme authority. Which of the following is described as a soul to the Constitution? Preamble, the basic idea of lawmaker. Preamble, objective resolution drafted and moved by Pandit Nehru. We means, the term we means Indian Parliament in the Indian regularity framework. Even people also be also a correct answer, I think. 7, 8 both are correct. The answer wrong. D. Not this. Not the Indian Parliament. People of India. Indian Constitution ensures justice in which of the following form? Social, economic, political, all the above. Preamble amended in the Amended Act 42 Constitutional Amendment. Preamble amended. In which case Supreme Court specifically opinion that preamble is not a part of Constitution. Barbary Union case. In which case Supreme Court rejected the earlier opinion that held preamble is an integral part of Keshav Bharati case. Learn it. The preamble states the Constitution derived from the authority people of India. Preamble, the date of adoption of Constitution, 26th November 1949. 42nd Constitutional Amendment added to the term preamble both A and B, socialist, Buddhist law, secular. Which part of Indian Constitution expressly declares that India is a sovereign, social, secular, democratic republic? Preamble. Mostly topic based on preamble only. Economic justice as one of the objectives of Indian Constitution provided in the preamble and directive principle of state policy. The correct sequence preamble is sovereign, socialist, secular, democratic, republic. This is the most correct one. You need to sovereign, social, secular. Sovereign, social, secular, democratic, republic. The constitution of which country was first to begin preamble? USA. The ideal of justice in the preamble draws the inspiration Russian Revolution. All are equal. Communist policy, Russian. Which of the following is true about the preamble? It is the source of power to legislate and source of prohibition and the powers of legislature. The ideals of liberty, equality, fraternity taken from Japanese constitution. The 42 constitutional amendment added the 4 words in the preamble, all the above. Which of the following is not determined in the preamble of Indian Constitution? Indians. The word sovereign mentioned in the preamble implies India is an independent state. Yes. India is neither dependency or a dominant of other nation. Yes. India is free to conduct own affairs. Yes. All the above. India independently perform, not yes influenced by others, can perform their activities on their own. Which of the following statement is true? Indian membership in Commonwealth nations. Commonwealth countries means yes. British Empire mostly ruled half of the known world. Yes, under the ruling British, what the countries is there, we call it as Commonwealth countries. Commonwealth games also. India also ruled by Britishers. Even it is a Commonwealth, yes, our sovereignty will not be affected. Yes, correct answer. Indian membership UNO does not limit the Indian sovereignty. Yes, correct. Indian can neither acquire a foreign territory. India never attacked any country. All the above. In which of the following the basic aims and objectives of Constitution preamble? What is the meaning of equality? Lack of opportunities, lack of equality, absence of listen sir. In India, a particular caste, particular religion, particular person, particular age, no special categories, all are equal unless specifically determined. Which of the following terms was not included in the Union of Trinity by B.R. Ambedkar? Flexibility, which means right to speech. Contract Act completed. Now we are having only 2 acts, Enact, LLP Act. Okay. Enact. Define 3 terms. Promissory note, bills of exchange, check, all the above. Banker. Banker, person acting as a employee of the bank, cashier or bank manager, or a post office saving bank. Here, banker means bank directly perform, bank employee will perform, they given directly. Which is not the example of a promissory note? IOU. Why, sir? A promissory note is an instrument in writing. In promissory note, how many parties? 2 parties, maker, payee. Which is not correct about the promissory note? Unconditional undertaking. A promissory note is an instrument in writing containing unconditional undertaking. Not correct it is. Enact extends to whole of India. Enact makes specific mention of 3 instruments: promissory note, bills of exchange, namely check, bills of exchange, and already they given 2. They are asking 3rd one, promissory note. Which one of the following is not a characteristics of negotiable instrument? It must be in writing. Why? Because printing also considered as writing. It's not a characteristic. A bills of exchange is treated as dishonored due to non-acceptance. Yes, okay. If bills of exchange need acceptance, it need to be accepted within 48 hours. Yes, and if you if drawee is an incompetent person, automatically dishonored. Conditional acceptance given by the drawee but payee not given the acceptance, automatically in above cases dishonored. A person holder in due course, holder, 2 conditions to be fulfilled: possession in his own name, entitled to recover from parties. Holder in due course, 4 bearer instrument, possessor, order instrument, payee, consideration, good faith, possession before maturity, all above. A negotiable instrument payable to order can be transferred by endorsement and delivery. In case back of instrument is full and endorsement on a slip of paper, it is a endorsement called as allongage. Material alteration. What is a material alteration? Altering the character or operation, altering the rights and liabilities without the consent of parties discharged. Yes, prior to such alteration. After receiving uncrossed check, its holder can make it general crossing or special crossing. If check is crossed, amount to be deposited only in the bank account. Payment of check containing special crossing can be obtained by deposit in the account. Negotiable instrument made without consideration, void. Inchoate instrument which not contain clear particulars. Yes, a failure to present a negotiable instrument should be presented for payment, who is primarily liable. Negotiation instrument said to be discharged when the liability of which of the following parties came to end, primarily liable. Undertaking contains only in the promise note. Which undertaking? Unconditional. Which of the following negotiable instrument not entitled for grace days? Bill of exchange. Oh, wrong answer. Bills of exchange entitled for 3 grace days na. Check no grace days. Yeah. D is the correct answer. Yeah. Grace days no. There is no grace days for check. After the dishonor of negotiable instrument, the holder may get the fact of dishonor authenticated by notary public. The noting can be done in the case of bills of exchange. Yes, bills of exchange. Why, sir? Wait. Acceptance required for bills of exchange. Noting and protesting required for bills of exchange. And in some case, promise or note also. So correct answer. You can take A and B also. A check is said to be special crossing when 2 parallel transfers drawn across the face of the check, writing name of the bank or name of some bank. Both are crossing. Promissory note must be in writing, unconditional, signed by maker, all the above. Bills of exchange is discharged when acceptor by negotiation back, it become maturity after maturity. Presentment of site is required only in case of promissory note. Which of the following promissory note presented for site? A note payable after site. Bills of exchange payable to bearer on demand. Valid, void, voidable, none of this. Why? Because it is payable to the bearer when a bills of exchange is an instrument in writing containing unconditional order signed by a maker directing certain person to pay certain sum of money to certain person, order of certain person, bearer of instrument. Last, directly it cannot. The term customer in relation to a banker means the person who keeps with the bank account. Duration not required. The payment of negotiable instrument become due third day. Third day. If the rate of interest not mentioned for compensation, 18%. LLP Act is the balance. Yeah, wait. An LLP is a body corporate, an entity separate from its members both. LLP is governed by LLP Act 2008. Whether a HUF can be a partner in LLP? No. How many designated partners? 2. Out of 2, 1 must be resident in India, stay in it at least for 120 days. LLP file Statement of Account and Solvency Form 8. Who is the authority for granting compounding of offences? Central government. Compounding means compromise. Leaving a person without punishment by imposing a fine. Compound means fine to be levied in place of punishment. What is the time limit LLP required to file a annual return? 30 days. Which of the following is true about the LLP? LLP is not a distinctive entity from members. No, not true. LLP is a legal entity separate from its members. LLP and partners are different. LLP is a body corporate, both B and C. For the purpose of LLP, resident in means who stay in India at least for 120 days. Wrong. Even all wrong. 120 days. Answer wrong, ma. LLP. Who stay in India at least for 120. Here partners. LLP Act resident means 120 days only. Question wrong. Total question wrong. Resident as per LLP Act. Designated partners 2. Out of 2, 1 must be resident in India, stay in India for 120 days. Here in LLP Act, resident means 120 days. Na? Question wrong. In which kind of partnership one partner has a limited liability, other partner has unlimited liability? LLP. As I said, sir, listen. In an LLP, partner's liability is limited. Where a partner commit any fraud willfully, his liability is unlimited. Any change in the partners of limited liability shall not affect the existence. Filing fees, contribution exceeds 5 lakhs but not exceed 10 lakhs. Both are wrong. Is wrong. Options, all options are incorrect. Contribution exceed 5 lakhs but not exceed 10 lakhs. It is around 2000 is the question wrong. An LLP partnership shall, where a person becomes or ceases to be a partner and where there is a change in the name and address of partner, shall file within 30 days of ceasing to be a partner. Every limited liability partnership shall have at least 2 designated partner. Out of 2, 1 must be a resident in India. In terms of section 23 subsection 2 of LLP Act 2008, every LLP shall file an intimation with regard to the LLP agreement in a prescribed form with the registrar within 30 days. What is the prescribed form? 3. Maximum number of persons. No, it is old one, Nana. Maximum no limit now. Maximum no limit. LLP earlier maximum limit is there, now no limit. Answer is this one. Earlier 50 is the limit, now no limit. Duration of LLP, yes, there is a perpetual succession. Dash is responsible for doing all the acts, matters, things which are required to be done. Designated partners. In company board of directors, in LLP, designated partners. Which of the following enjoys a separate legal entity status? LLP, company, both. What is the primary advantage of LLP? Yes. Limited liability for partners, tax advantages of partners. Why? Because LLP and partners are different. In an LLP, which of the following is true regarding the personal assets of firm? Personal assets are liable only when there is a fraud. Liability limited, liability unlimited in case of willful fraud. Which document requires to establish LLP agreement? Who is responsible for day-to-day management of LLP? All part. If designated partners is there, then designated. If no designated partners, all partners equally. In an LLP, which type of partner typically responsible for signing agreement and legal documents on behalf of partnership? One best possible answer, managing partner. Directly you can call it as designated partners. All are incorrect. Best possible answer you need to write, as I said. What type of professionals often required to form a LLP in certain jurisdictions? CA, CMA, CS, advocates. Mostly CA. Medical professionals are not allowed. But in regarding to a medical professional thing, they can. In an LLP, which partners are typically not involved in day-to-day operations and decision making? Limited partners. Primary disadvantage compared to it is a easy of formation is a advantage. Limited liability, taxation, all are advantages only. They given one answer that we can't do anything. How many schedules? 4 schedule. Schedule 1, mutual rights and duties. Schedule 2, conversion of firm into LLP. Schedule 3, conversion of private company to LLP. Schedule 3, conversion of unlisted public company to LLP. So, some questions which are incorrect, you need to change and write. And welcome to the Companies Act. Small shareholder means a shareholder whose value less than 20,000. Small shareholder director can be appointed as if an application made by 1/10 of small shareholders or 1,000 small shareholders, whichever is lower, not there. It is there in the earlier 2016 syllabus. Women director, even there, I given in the book. Even not there, I given in the book. Okay, all the best. So, MCQs, we already covered now. Tomorrow, while you going to the examination, last hour revise it. Last hour. As I already said, Contract Act, Directors, Ethics. Don't see important, unimportant in these 3 topics. If you go by selected. Wind up the class. All the best. Bye.